I am Oren Onken. I am a probate and elder law lawyer who practice outside of Portland, Oregon. This is the second in a series of videos of what happens to your property when you die. In my first video, I talked about personal property. In this video, we get to the property that people in the legal profession actually care about: real estate and financial accounts. When you die, your property will pass to others in one of three ways. Those ways are 1. Joint ownership, 2. Beneficiary designations, and 3. Your will. If you have an estate planning trust, just substitute trust for will. In this video, I'm going to talk about the first way that property passes to others: joint ownership. It will be easiest if I start with deeds. Deeds determine who owns real estate. If the deed contains only your name, you probably own the property in fee simple. Fee simple is simple and is the best way to own property. With fee simple, you can sell the land or give it away without having to involve anybody else. When you die, property owned in fee simple passes to your relatives according to the instructions in your will. If, however, you own property with another person, the property may or may not pass by will. If you own property with a business partner or someone who has no part in your estate plan, the deed will probably provide that the two of you own the property as tenants in common. That means that each owner holds a percentage of the property. With two people, it is assumed that each owns one half. I don't mean a physical division of the property, but a fractional ownership in the entire parcel. If you die owning property as tenants in common with another person, your half ownership goes to the people named in your will, and the other owner ends up owning property with your relatives. They may not like that, but that's the way it works. If, however, two owners are husband and wife, the deed will most likely say that the two people own property as tenants by the entirety. This is a special kind of co-ownership only available to spouses. If you die while owning property as tenants by the entirety with your spouse, poof! Your spouse now owns the property in fee simple. Nothing has to be done, and the day after you are dead, your wife can sell the property and move to Argentina with her new boyfriend. The deed has created a right of survivorship in each spouse so that when one dies, the other owns the property in its entirety. Here in Oregon, if you deed property to people who are married, the deed creates tenants by the entirety even if the deed doesn't explicitly say so. The law in other states varies. In estate planning, creating rights of survivorship is a big deal. Some people want to hold property with another person and create the same kinds of rights that spouses have when they own property as tenants by the entirety. These folks opt for joint ownership with right of survivorship. This will vary state by state. Oregon abolished joint ownership, but allowed it to live on if the deed sufficiently describes the survivorship provision. In Oregon, it is technically concurrent life estates with cross-contingent remainders. That is fun to say, and I once put that into a deed on some property I owned with another person just because it was fun to do. I see a lot of people get all excited about using a deed and survivorship to do their estate planning. They like the idea, they tell me, because it's simple and it avoids probate. It is not a bad idea. Neither is it a good idea. It is a mediocre idea that sometimes works well and sometimes not. If you thought this up yourself or learned about it from your barber or your nephew who is thinking about going to law school, don't go all Google-eyed about it. Many times creating survivor rights in your real property as estate planning creates more problems than it solves. But all that is for another video. In this one, we just learn how joint ownership works. So now let's talk about joint accounts. By accounts, I mean bank accounts and investment accounts. We know that in real property, if two or more people own the property, the owners may or may not have survivorship rights. Spouses do, joint tenants do if the deed is written correctly, and tenants in common don't. With bank and financial accounts, there is one rule. If the account is jointly owned, when one owner dies, the other gets the money. Depending on your state, heirs can go to court and try to prove that the dead owner never intended that result, but doing that requires you to pay a person like me a lot of money. The basic rule is that the survivor gets the money. This rule is primarily designed to benefit banks. If you and I have a joint account and I put 90% of the money in the account and you put in 10%, the law is that if you and I get into an argument about whose money it is, I get 90% and you get 10%. The bank, however, has no idea where the money comes from. It just knows that both of us can take as much as we want out for any reason or no reason. When I die, the bank still has no idea where the money came from, so it will treat the other owner as the sole owner. Without this rule, banks would be in such a pickle that they would probably stop offering joint accounts at all. So if you and somebody else are co-owners of a bank account or investment account, when one of you dies, the other gets the money, no matter what your will says or how your relatives feel about it. Between spouses, this tends to work pretty well. If you are thinking about making your son, daughter, nephew, cousin, hairdresser, or that guy who is repairing your roof co-owner of your financial accounts, you might want to think twice about the downstream consequences. A lot of elders use that horrible phrase, "put so-and-so on my account," as a method of doing disability planning. They expect so-and-so to pay their bills if they get dementia. That is another mediocre idea, usually proposed by so-and-so. Sometimes it works out and sometimes not so much. However, putting so-and-so on those accounts does mean that when the elder dies, so-and-so gets the money. So-and-so might decide to share the wealth with other relatives, but doesn't have to, and from what I see in my office, probably won't. So let's get back to what we came here for. What happens to jointly owned property when you die? If it is real estate and you own it with your spouse, it goes to your spouse. If you own it with somebody else, it depends on whether the deed has created survivorship rights or not. If not, it goes to the people named in your will. With financial accounts, if the account has two owners and one owner dies, the other one gets it. With a couple of very expensive exceptions, the dead owner's wishes about that money don't matter. So that is more than you ever wanted to know about what happens to stuff when you die, jointly owned property. In the next video, I move on to beneficiary designations. For more of this kind of stuff, visit my website and blog at orolaw.com or Google my name.